It prevents him from his livelihood for a business that he founded. The business is being wasted.
But what he has done is try to bring down the business by taking funds out for his own personal use, bribing employees, scaring employees, filing false police reports at their cottage and here in town. Just last night, he called the cops for a welfare check on his child living right next door.
Cutsley versus Cutsley, case number 24-05780-DM. Present in the virtual courtroom, we have both parties along with their respective attorneys, Ms. Van Dyken on behalf of the plaintiff, Ms. Cutsley, Miles Murphy on behalf of the defendant, Mr. Cutsley. We are here on a couple of issues. First is the defendant's objection to the ex parte order that the court issued, as well as a motion for an order show cause. Mr. Murphy.
Yes, Your Honor, I'll handle that objection then first, please.
Okay.
Your Honor, under MCR 3.207, it's our position that there has been no showing of specific facts by way of a short 3 to 4 paragraph affidavit or the bald allegations of Ms. Van Dyken of any irreparable injury or loss or damage. And we are asking the court to dismiss the ex parte and phase back into what's already in place, the stipulated temporary order, which was entered back recently in the case on 8/26 of 24. I would note there is an STO, which I just noted. The plaintiff did obtain a PPO, which entered on 9/25 on the heels of the ex parte, apparently. And again, we have strongly opposed and objected to the PPO, which is now scheduled for hearing in a few weeks. Bottom line, Your Honor, this is a very high conflict case. The parties have been separated since roughly April to May. They have this auto body business. Fortunately, to my knowledge, there is not an issue regarding their 2 children. So it's an issue dealing with property and debt. My position on the objection is that the ex parte unreasonably handcuffs the defendant, my client. It prevents him from his livelihood for a business that he founded and or bought in 2008. Then the parties got married in 2015. We have at least 7 to 8 years of premarital interest in this business. My client was always the one with the mechanic's license. He developed the business, he nurtured it. Plaintiff Janelle did enter the business a few years ago. The reason my client was temporarily out of the business in roughly the summer of 24 forward was because the parties had talked about Janelle buying out my client's interest. Now that's totally off the table. We're not in favor of her buying out the business because it's going to go under. The business is being wasted. It's being mismanaged. Employees are being improperly treated. And there's a lot of financial red flags, Your Honor. The red flags are something that I can, again, just reiterate. I won't rehash things, but in my motion for an order to show cause. So we're respectfully asking that the that the ex parte be dropped and that my client be permitted to have access to the business. And the relief that I am going to be asking for also in my motion to show cause includes a couple things that the parties have been exchanging information on back in August. They had settlement negotiations, which are private. They did fall through, but based upon those negotiations, my client agreed to let Janelle come in and operate the business short term. It has not been going well. Also, my client had agreed to, they have about 5 or 6 other properties. My client agreed to build and move forward with a house in Kent City for the plaintiff to move into. That has started, but there have been delays on the foundation and the sanitation issue. But we think that can be solved by number one. Right now, the parties are living next to each other with a PPO in place. The marital home is next door to the defendant's parents' home. About 100 yards or so separate them. So that's caused some conflict. We suggest that plaintiff move either into her mother's house or that defendant be permitted to move into their duplex. They own a duplex on Maple Street, I believe in Sparta. That lease terminates on November 1 with a renter. My client would be able to then move away from Janelle and into the Maple Street address starting on or about November 1. I believe Janelle had opposed that as of now. So, Your Honor, we are asking the court, I'm not trying to be long-winded, but there are a lot of pieces in this. We do have mediation set now for November 25 with Mary Benedict. That's definitely needed. We respect the PPO, but we are objecting to the PPO. And we're stating that the plaintiff's own unclean hands or bad faith and inadequate showing of specific facts justify dismissal of the ex parte order, Your Honor. Thank you.
Ms. Van Dyken.
Thank you, Your Honor. All of that is false. The business is going very well. I think the court has reviewed the pleadings, letters written by employees about Mr. Cutsley's lack of engagement in the business. Even yesterday, he called one of the employees and tried to bribe him not to come to work. That's Rodney. Yeah, Mr. Cutsley, he let us know. This man has gone in and just taken funds from the business that he is not working at, nor is he working on the Kent City home. What he did do is the Maple Street home, he went and unilaterally told the tenants, you can leave, we'll let you out of your lease anytime, where we had leases. So he's unilaterally doing things to impede funds coming in to the family. He can stay at his parents' house. It's right next door. This court signed a PPO violation just yesterday. Mr. Miles, Mr. Murphy, check your email. He's got a violation of the PPO. He is not appropriate to run this business. He lies to you in pleadings that he completed rehab. He left after 36 hours and got a refund. From April of 2024 through October 4th of 2024, Mr. Cutsley was paid about $48,000 from the business that he was not running, that he was not taking a part of. But what he has done is tried to bring down the business by taking funds out for his own personal use, bribing employees, scaring employees, showing up drunk to many things, tearing down cameras, filing false police reports at their cottage and here in town. Just last night, he called the cops for a welfare check on his child living right next door. This man is in no condition to run this business. I believe the ex parte should stay in place. He has access to all of the information through Mr. Roger Boersma, their CPA. He's been the CPA for the business for 40 years. He can have access to what's going on, what's being paid, what's not being paid. But right now, my client's responsible for making all the payments on everything. It was Mr. Cutsley who unilaterally one day, probably drunk, called up the electrical company and said, turn off the power to my house. And so my client's in the house with the kids, one of them sick with 101 fever, with no power. He's doing everything to put up hurdles in this divorce. These parties were working on an agreement. I would agree with Mr. Murphy, but that's no longer on the table because of all the shenanigans that Mr. Cutsley's been paying. Your Honor, I'd ask the court to keep the ex parte in place. I'm happy to talk with Mr. Murphy and the CPA about what's been happening with the company, what's been coming in, what's been going on. My client's trying to run that company. He's doing everything to stop it. He took the dump truck that they utilized for the company to take away all these parts and scraps. They can't do that now. Now they're piling up. He's not fit to run this company. He's not, quite frankly, I'm pretty concerned that he hasn't finished his rehab. Mr. Murphy says he did, hasn't provided anything. We know he got a refund check from rehab. I don't know which rehab sends a refund check when you complete rehab. And what
She's
rehab
repeating
goes for
herself,
36
Your Honor.
hours. So he has money because he got a refund from the rehab of $1,900. Your Honor, the ex parte needs to stay in place. My client will plead not guilty to the order to show cause. We can set it up for hearing. Quite frankly, we do need to get into mediation on all of this.
Your Honor, again, I would just respond briefly that my client has run the business since 2008 for 18 years. He has been the primary operator. He removed himself a few months ago because of a informal divorce discussions. Now that's off the table. He does want to run the business because he sees what is going on. It's going in a terrible direction. And I would just note that, make no doubt, the business is a priority. His family is a priority. Respecting the court orders is a priority, but protecting KBS is an absolute priority here. So I would ask that the ex parte is not necessary and that it be removed.
All right, the court finds that the plaintiff has met the requirements of the court rule MCR 3.207. The court is very concerned about the finances of these parties, and obviously on a Friday morning it's very difficult for the court to figure out what exactly is going on. That's really an issue for trial. I really encourage the parties to make the best use of this mediation that's coming up, because this litigation is going to take whatever money the parties and assets the parties might have available, and dissipate them just through litigation alone. So I just really encourage you to try to work this out yourselves. And I will deny the motion order show cause.
Thank you, Your Honor.
But I do encourage the parties to share information regarding finances through this accountant or however that needs to happen.
Your Honor, and I know you have a busy docket, but on the motion for an order to show cause, we had outlined a number of red flags that we tried to, again, highlight about problems and concerns on page 3 of my motion. Again, my client is being paid nothing. His monthly draw and his weekly paycheck have been cut. He has no other income right now, and she has hijacked the business.
I understand all of that, but I also heard that he's received significant amount of money in the past couple of months, and that he received a fairly significant refund from the rehab facility. You do have mediation coming up in a couple of weeks, and I think that's where this needs to be worked out.
Thank you, Your Honor.